inferior. You know I'll always be a bit superior. Get off of me, this ain't no humble.
Good afternoon, everyone.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. Everything I do so instinctive and so passionate. Every word I move so descriptive like an adjective. I got a vendetta against people who patented being negative when you should be getting after it. I got backs over tracks, just in that spitting slow, spitting fast. I could roast, I could gas, think I'm okay at last, but I don't know if that can open the pettiness. A reflection of the emptiness, hilarious. You think you're worth my time, you're delirious, mysterious because you hide behind a fake exterior, inferior. You know I'll always be a bit superior. Get off of me, humble brag. I want you to hear words, you can say them back. I want you to feel free from the chains that last, and to believe in what you got, it was built to last, yeah.
Now that I've been put through hell, I never got anyone's help. I had to do it all myself.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
Gonna learn the consequence of being incompetent. Mental health is confidence, dreams and some honestness. I'm not here to save the day, that's for you to take away. I could play a million mind games, but instead I say something not illogical, something that is topical. Rub it on and watch it go, make yourself unstoppable. Dreams are irresponsible, but they're always possible. If you just believe, you could be so remarkable.
Thoughts in my head, a collage and they spread. I'll be great one day going off of my meds. No, I'm not giving up, no, I'm not giving in. I will make it to the top, taking off in the wind. I gotta make it, I'm saving every day to taste it. I'm patient, but my mind, it can hardly take it. I'm chasing a dream that I've had for several ages of vacant. Modern kingdom for the taking.
Now that I've been put through hell, I never got anyone's help. I had to do it all myself.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
I don't ever slow up, no I don't take shit. I got no love for fakeness. If you wanna play tough and wanna hate this, I'll always show up. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
Everything I do so instinctive and so passionate. Every word I move so descriptive like an adjective. I got a vendetta against people who patented being negative when you should be getting after it. I got facts over tracks, this and that. Spitting slow, spitting fast. I could roast, I could gas. Think I'm okay at last, but I don't know if that can erase all the past.
And the pettiness, a reflection of the emptiness. Hilarious, you think you're worth my time, you're delirious. Mysterious, because you hide behind a fake exterior. Inferior, you know I'll always be a bit superior. Get off of me, this ain't no humble brag. I want you to hear words, you can say them back. I want you to feel free from the chains at last, and to believe in what you got, it was built to last, yeah.
Now that I've been put through hell, I never got anyone's help. I had to do it all myself.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
Gonna learn the consequence of being incompetent. Mental health is confidence, dreams into modestness. I'm not here to save the day, that's for you to take away. I could play a million mind games, but instead I say something not illogical, something that is topical. Rub it on and watch it go, make yourself unstoppable. Dreams are irresponsible, but they're always possible. If you just believe, you could be so remarkable.
Thoughts in my head, a collage and they spread. I'll be great one day, going off of my meds. No, I'm not giving up, no, I'm not giving in. I will make it to the top, taking off in the wind. I gotta make it, I'm saving every day to taste it. I'm patient, but my mind, it can hardly take it. I'm chasing a dream that I've had for several ages. A vacant, modern kingdom for the taking.
Now that I've been put through hell, I never got anyone's help. I had to do it all myself.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
Everything I do so instinctive and so passionate. Every word I move so descriptive like an adjective. I got a vendetta against people who patented being negative when you should be getting after it. I got facts over tracks, this and that. Spitting slow, spitting fast. I could roast, I could gas. Think I'm okay at last, but I don't know if that can erase all the past.
And the pettiness, a reflection of the emptiness. Hilarious, you think you're worth my time, you're delirious. Mysterious, because you hide behind a fake exterior. exterior, inferior. You know I'll always be a bit superior. Get off of me, this ain't no humble brag. I want you to hear words, you can say them back. I want you to feel free from the chains that last, and to believe in what you got, it was built to last, yeah.
Now that I've been put through hell, I never got anyone's help. I had to do it all myself.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
Gonna learn the consequence of being incompetent. Mental health is confidence, dreams and some honestness. I'm not here to save the day, that's for you to take away. I could play a million mind games, but instead I say something not illogical, something that is topical. Rub it on and watch it go, make yourself unstoppable. Dreams are irresponsible, but they're always possible. If you just believe, you could be so remarkable.
Thoughts in my head, a collage and they spread. I'll be great one day, going off of my meds. No, I'm not giving up, no, I'm not giving in. I will make it to the top, taking off in the wind. I gotta make it, I'm saving every day to taste it. I'm patient, but my mind, it can hardly take it. I'm chasing a dream that I've had for several ages, a vacant modern kingdom for the taking.
Now that I've been put through hell, I never got anyone's help. I had to do it all myself.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
Everything I do so instinctive and so passionate. Every word I move so descriptive like an adjective. I got a vendetta against people who patented being negative when you should be getting after it. I got facts over tracks, this and that. Spitting slow, spitting fast. I could roast, I could gas. Think I'm okay at last, but I don't know if that can erase all the past.
And the pettiness, a reflection of the emptiness. Hilarious, you think you're worth my time, you're delirious. Mysterious, because you hide behind a fake exterior. Inferior, you know I'll always be a bit superior. Get off of me, this ain't no humble brag. I want you to hear words, you can say them back. I want you to feel free from the chains that last, and to believe in what you got, it was built to last, yeah.
Now that I've been put through hell, I never got anyone's help. I had to do it all myself.
I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement. I don't ever slow up, no I don't take shit. I got no love for the fakeness. If you wanna play tough and wanna hate this, I'll always show up and make a statement.
Gonna learn the consequence of being incompetent. Mental health is confidence, dreams and some honestness. I'm not here to save the day, that's for you to take away. I could play a million mind games, but instead I say something not illogical, something that is topical. Rub it on and watch it go, make yourself unstoppable. Dreams are irresponsible, but they're always possible. If you just believe, you could be so remarkable.
Thoughts in my head, a collage and they
Keynote
spread. I'll be great
speaker
one day,
reviewed
going off of my
and
meds. No, I'm not
organized for a national and international conference, workshop and webinar. Her dedication towards research, innovation and outcome based on education reflected her commitments to academic excellence and social development. It's over to you, ma'am.
I don't ever
Thank you, Jyoti. Am I audible clearly?
Yes, ma'am.
Hello.
Yes, ma'am.
Am I clearly audible?
Yes, ma'am.
Thank you, Jyoti. Shall I start my screen? Is it visible? Hello? Is my screen visible?
No, ma'am.
1 minute. Hello? Is my screen visible?
Yes, ma'am.
Hello?
Yes, ma'am.
No. I think there's an issue with the system over here. 1 minute. I'll just again try back.
Yes, ma'am. Your PPT is visible now.
Thank SME Skill Activate and National Professional University for providing this opportunity. I'm Dr. Preeti Chincholikar, Professor in Chemistry from National Professional University, Bhopal. I am glad and happy to share that I've been given an opportunity to provide a visionary topic on effective IPR filing and drafting strategies for beginners. Is this
Ma'am, sorry. Ma'am, your your voice is not audible, ma'am.
what happened?
Your voice is not clear.
The voice is not clear. This is not on. Hello? My screen is visible or not?
Yes, ma'am. Yes, ma'am.
Hello?
Still,
Yeah. So, I'm going to talk about the spheres of your learning content. That is, we'll deal with the basics. What is IPR, types of IPR, importance of IPR in academia, global IPR framework,
Ma'am,
then
you have
innovation.
unshared your screen, ma'am. You have unshared your screen.
My screen is unshared. 1 minute. 1 minute, I'll get back. Okay. Hope my voice is clear. Am I audible? Am I audible?
Yes, ma'am, you're audible,
Yes, ma'am.
but PPT is not visible, ma'am.
Am I audible?
Yes, ma'am.
Yes,
Is my voice clear?
yes, ma'am.
Okay. Dear audience, I'm extremely sorry. There's an issue with the laptop, a technical glitch. I'll just connect with the mobile here. Kindly bear with me. Just few seconds. I don't know.
Yes, ma'am. Any problem, ma'am, in
Yeah,
TP?
there's a disconnection in between, network error. Just few minutes.
Okay, okay, ma'am.
I'm just uploading my PPT into mail so that I can grab it, download it on the mobile. Kindly bear with me. Thanks a lot.
Ma'am, or else we can share your PPT, ma'am. We can screen share our PPT. Okay, ma'am. Hello, ma'am. Hello.
Hello? Yeah, you can share the
Yes, ma'am.
PPT, no problem. No problem.
Okay, ma'am. Okay, ma'am. We will
Yeah.
share you. Okay, ma'am.
And when I say kindly share, kindly shift, then you can see. Okay? Yeah.
Okay, okay, ma'am. We will share, ma'am. Thank
Okay.
you.
Okay. Thank you.
We will share, ma'am. Thank you.
Yeah, sure.
Yes, ma'am. We will screen
Even I
share
have
our PPT.
downloaded it. Yeah, even
Yes,
I have
ma'am.
downloaded.
We
No
have the
problem.
PPT. We have the PPT. We can screen
Yeah.
share our PPT.
Okay.
Thank you,
Yeah,
ma'am.
sure. Kindly share it, sir.
Okay, ma'am.
Kindly share it with the screen share mode, slideshow mode, please. Once again, thank you, patient audience, for providing me this opportunity. Sorry for the technical glitch that has occurred right now. Thank you once again. I thank MSMEs, Skill Activate, and Madhanchal Professional University, Bhopal, for providing me this opportunity and giving me this opportunity to talk about effective IPR filing and drafting strategies for beginners. Next slide, please. So, next slide, sir. Excuse me, can you? Yeah, thank you. So we'll go through the spheres of your learning content. This learning content sphere consists of basic introduction to IPR and the types of IPR, the global framework, and the organizations and agents that are working in this, along with the Indian IPR ecosystem. Apart from this, we'll go through the innovation life cycle, novelty assessment, criterias, what are patentable subject matters and what are non-patentable subject matter, the flow chart, how to identify patented work and how to search the flow chart, and then what is a provisional patent and how we draft the patent by understanding the structure, that is patent components in detail, provided the time permits. Anyhow, I'm going to put in my efforts to complete complete as much as possible and make it as easy as possible for you people to understand. Thank you once again. So, what is IPR? IPR stands for Intellectual Property Rights. In simple words, it's the ownership of your own thoughts, ideas, creations, and inventions that is
solely your own mental ability has created. Just like any physical property, like a house or a car you own. Here, IPR gives you an ability, or rather, it is the right to use your intellectual property or mind made things from preventing it from being used or copied by other people without your will and wish. So we'll go through what are the types of IPR. There are different categories of IPR. The four different categories that are copyrights, patents, trademarks, and trade secrets. The copyrights are the generally creative and artistic works. This is dealt in literary work, music, painting, software codes, etc. And it ensures that you, without your prior permission, no one can copy or sell it. Patents. Patents are any kind of brand new inventions that are used for mankind's benefit and is utility of daily life. This can be a simple medical device or any machine, and its inventor gets an exclusive right for a period of time to make and sell the invention. Generally, it is around 20 years. Trademarks, these are the brand identities like logos, slogans, or brand names and symbols. For example, you might have experienced or seen the labels of Coca-Cola or Britannia or any Lux, anything, any brand that is under FMCG, okay, the consumer goods, and that you'll come across a superscript mentioning TM. TM means trademark applied. If it is given a symbol of R in a circle, that means the trademark or the brand name or the logo is legally registered for trademark. That means such brands, logos, slogans, and anything under the company's umbrella cannot be used to confuse in a similar way, or the brand name, like if you come across for example like Domino's pizza, it has a blue and red dice like dots, so that is a symbol of Domino's pizza. If you comparatively, if you change it or if you give a different name, just confusing the customers, then you will face a legal action because it is a trademark registered logo. Then trade secrets. Trade secrets like Cadbury's has, Coca-Cola has, and Google has its own search algorithms. So these are certain trade secrets which are which falls under the company's competitive IPR strategies. What is the importance of IPR in academia? In academia, it is highly important because bubbling minds, innovative thoughts mushroom out at the fertile land of universities, institutes, and colleges. So, here we go through different research aspects. Generally, students or faculties create their own projects, inventions, some creative works take a shape in the institutional level. So, IPR is utmost important in academia. Certain benefits will go through, that is, it is helpful in technology transfer and commercialization. It is helpful in attracting funding and partnerships. Funding in terms of private companies or VCs, that is venture capitalists, will invest in certain research or certain inventions, which may be helpful in marketing into the public, right? And can generate some revenue. Such ideas and such patents are usually taken up by companies and venture capitalists. It also helps in incentivizing and protecting the researcher's motivation. Yes, You have designed a vehicle, or you have designed something, you have invented some process, you have discovered some process, or you have designed some material. So in that case, the researchers innovation is highly protected, because legally it gives them the right to have some commercial royalties. It also helps in preserving the academic integrity by maintaining the ethical standards, preventing plagiarism, and also it helps in institutional reputation and revenue generation. Moreover, it is a pride matter for universities too, along with the academicians. So the IPR works on a certain global framework. And this global framework is a centralized part of international treaties, conventions, and organizations that help in creating inventions and branding and protecting them across the borders. That means if I have a patent on certain product or certain design or certain idea that is unique to only me. Nowhere in the world anybody can claim it to be their own. Okay, same was the case with turmeric. Turmeric was being claimed as a patented material from USA, but Indians have been using it since ancient times. So, for such things, core regulatory bodies like WIPO, that is World Intellectual Property Organizations, the, under the integrities of World Trade Organizations, are working together under the TRIPS agreement. This is trade aspects of intellectual property rights, where they help in setting some minimum standards of IP protections, mandates of enforcement procedures. It falls under different conventions, Paris and Berne conventions. Paris Convention is concerned with patents, trademarks, and industrial designs throughout the world, whereas Berne Convention is exclusively working through copyrights. Then global IPR framework also helps in streamlining the systems, maintaining the patent cooperation treaty, uh, and it falls under the Madrid system, where the brand owners apply and manage the trademarks, and it is controlled around 132 territories through a single international application. Modern challenges in this is enforced generally by domestic legislation, and certain tensions remain between the balancing of innovation and research, and also public interest and access, that is generally for the fair use of health conditions. So, what is WIPO? Let us have an overview of WIPO. World Intellectual Property Organization is a specialized agency under the UN that promotes protection of IP worldwide, and it is established in 1967. Its headquarters is in Geneva, Switzerland. More than 190 countries are involved in it, and helps in claiming and protection of international system. The major areas of IPR covered by WIPO is patent indications, traditional knowledge, and generic resources, key international treaties administered by WIPO. So WIPO uh, works with the system of PCT, Patent Cooperation Treaty, Madrid system, Hugh system, Berne system. This we have already discussed in the previous slide. So WIPO also helps in patent filing. WIPO helps in identification of different researchers and patent maintenance of patent databases like patent scope, It also helps in conversion of technology and technology transfer, that is technology and innovation support centers, and helps in uh, commercialization as well as IP management guidances for universities and startups. WIPO helps in India. It is helping in Indian researchers, universities, startups uh, for applying the international patent, trademark, and design protections. So the TRIPS agreement, this is other part of tra- uh, patent treaties, that is trade related aspects of IPR. It has come into force in 1995 January 1st, and it helps in maintaining and establishment of minimum standards and protection and information enforcement of IPR. Because of the trade TRIPS agreement, there is reduced distortion and barriers to international trade. That encourages innovation and technology transfer, balances the interest of IP owners and the public, ensure fair enforcement of IP rights. So, the major aspects that is covered is copyright and related rights, trademarks, geographical indication, all that is covered under WIPO, but it gives an additional advantage, protection against unfair competition. So, the key provisions are minimum standards of protection, national treatment, that is, foreign national must receive the same IP protection as a country's own citizen. Most favored nation treatment, any advantage granted to one WTO member must be extended to all WTO members. Patent protection, it is available in all fields of technology, and the minimum term period is 20 years from the date of filing. And the patent rights include exclusive make, use, and sell and import the invention that is under the patent's owner. Enforcement mechanisms are provided at all countries in the same manner. So civil remedies that comes under TRIPS agreement is administrative remedies, border measurements. Next slide, please. Uh, Administrative remedies, border measurements, criminal procedures for serious infringement. Next slide, please. Next slide, please. It is also helpful in identification of certain disputes and their settlements between different member countries that are under TRIPS agreement, and also helps in identification of certain disputes that is under WTO, that is World Trade Organization settlements. Next slide. Doha Declaration on TRIPS had occurred on 2001, that clarifies that members and the countries may take measures to protect public health and improve access to medicine emergencies that we had experienced in COVID-19. Kindly next slide, please. Next slide. Hello. Hello. Next slide, please. Hello. Is the screen visible? Hello. The
Yes,
slide
ma'am,
is
tell
not
me.
on the screen show mode, please.
Okay, ma'am. Okay.
Kindly share it. Hello. Trips in India. Hope it's hello.
Yes, ma'am. Yes, ma'am. Tell me.
You have come forward in the yeah. The slide is far away. I mean, mm, go back, go back. Wait, wait. Yes, here. Next, next, next. Come forward. Can we share the screen? It's
Only, ma'am.
next slide, please. Not this one. This is over. Impact on India. There, that slide title is Impact on India. Is there any problem with the, is there any issue? Hello?
Yes, ma'am.
Yeah, the title of the slide is Impact on India before trips, after trips compliance. If not, I'll continue. But finally, next, advantages of trips. Impact on India, you've opened. Okay, impact on India. India's patent regime in IPA, that is Indian Patent Act 1970, has recognized process patents for pharmaceuticals and agrochemicals. After the TRIPS compliance in 1999, 2002, 2005, there are different major changes like introduction of product patent in pharmaceutical and chemical like patent terms can be extended to 20 more years, stronger enforcement of provisions, compliance with international IP standards. Now, what are the advantages of TRIPS? It encourages innovation and R&D, facilitates, next slide please, facilitates international trade, attracts foreign investment, kindly shift to next slide, promotes technology transfer, creates a predictable IP framework. There are also criticisms of TRIPS because of increased price of patented medicine. It can limit the access to technology and in the developing countries. It may benefit only the developed countries more than the developing nations and creates challenges for small industries and generic drug manufacturers. Next slide, please. TRIPS at a glance. It is a cornerstone international agreement governing intellectual property rights within the global trading system. It has minimum standards of IP protection among WTO members while balancing innovation, trade, and public welfare consideration. Next slide, please. We have this table in which the feature and description of TRIPS is clearly mentioned. Agreement name is TRIPS, administered by WTO, effective from 1st January 1995, sorry. Patent term is around 20 years. Coverage, it covers patents, copyrights, geographical indicators, trademarks, design, trade secrets, principles, national treatment, and MFNs, and importance, global minimum standards of IP protection. Next slide, please. Hello, it's next slide. Yeah, next slide. This table is mentioned now. Yeah. Now coming to IPR, Indian IPR ecosystem. This is the logo of our, next slide please. Hello, yeah. This is the logo of our Indian intellectual property right, that is IPR India. So the patent filing procedure in India has this, we should follow this flow chart. Filing. The filing is filling up the forms and writing the descriptions, etc. to publication. Generally, it is going to take around 18 months months' time. If the publication is done, then the pre-grant side chart, pre-grant rights, the application undergoes examination without any opposition, the issuance of FER, that is first examination report, then filing response occurs, then the grant is done, grant is notified, and post grant opposition is also considered. If there is no post grant opposition, then the patent is granted. If there is a post grant opposition, then the patent is refused. Before the grant stage, this whole process takes around 48 months till issuance of FER. Then, generally, I'm talking about the general procedure. Then, further examination report or first examination report after filing the response is also here undertaken for hearing. If it is refused, then the patent is cancelled. If after hearing there are no claims, I mean there are no oppositions, then the grant is followed for the grant certificate. This consumes around 12 months of time. Next slide, please. Patent versus other IPRs. So, next slide. Next slide, please. Yeah. Here you can see a classification of types of IPR. Intellectual property. This is classified under industrial property, copyrights and related rights. Under industrial properties, you come across industrial designs. The design of the Coca-Cola bottle is an example. Patents for Coca-Cola logo or names, brand names, etc. Trademark and service marks. Under copyright. Next, what is the difference between a trademark and a patent? This tabular form can clearly give you what is the difference. Trademark protects the brand identifiers, whereas patent protects inventions. It protects trademark protects names and logos. In patent protects products and processes. Scope of protection. Trademark prevents others from using trademark in connection with their goods or services, while patent provides right to exclude others from making, using, and selling of the invention. The best examples are trademark is Nike, whereas patent iPhone's internal circuitry or a new drug compound. Registration process, trademark application to the United States Patent and Trademark Office. Patent, submit patent application to United States Patent and Trademark Office. When concerned to India, it is concerned to Indian IPR India. In terms of protection, it can last indefinitely if renewed. I can take up my logo, company logo, I can register it for trademark, and then after a tenure period of 8 years, 20 years, whatever, then I can renew that. So I can keep it as my sole ownership. Whereas patent, it is only for 20 years of utility, and after that, the rights of total ownership is lost because the patent has to be for the public well-being. Effect of public disclosure. Trademarks have no effect on registration process, but patent must be filed within 1 year for public disclosure of the invention. Now, we have learnt about the basics of trademark and patent, but what is the process, how the innovation works and comes into the patent. So, innovation life cycle is an aspect. So, innovation life cycle comes with the idea. First and foremost thing is you have some different idea, different approach to certain problems. Ideation, then your idea is further progress into a concept. You have an idea and you have some theories, applications, or hypothesis that you create a concept out of it. Once a concept is implemented, you take the concept and design certain prototypes. That becomes a solution. Once the prototype is generated, if that prototypes work perfectly and give you the desired result, then the prototype can be designed in advanced modes and can be marketed. So this is the life cycle of a innovation innovation life cycle. The phases being ideation, concept, search, solution, and marketing. So, for if I have an idea, so what is the criteria that my idea is patentable? This is, I can show you some components that is kept in a funnel. First of all, your idea should be novel. It should not be it should not be very obvious, very clearly, easily available or easily understandable. It should be something very rare and it should be of high utility. It should not come under non-patentable subject matters, and also the data and results with your novel inventions should have sufficient data to support the desired results. How will you assess your novelty? Whether your patentable idea is novel, it has the following flow chart. You take that new product, compare the functions of the product with the functions of the other products. First of all, you think over whether the function exists. If it is existing, the product may, if it is not existing, surely it is novel. If it is not existing, it is surely novel and very high novelty product category, it can be kept. Whereas if it is having the similar functions, it can be a novel one, but it should be compared again. The processing goes, yes, the product is not novel. If the structure is same, the product is not at all novel because you are copying, and then you compare it with different materials of construction and kindly share the screen. Hello. The screen is not visible. Hello? Hello?
Yes, ma'am. Hello? Yes, ma'am.
Uh, I'm continuously going through, but the slides are not moving
I
off
will check
and
it,
the
ma'am.
screen is
Please wait.
not visible at all. As such, do you want me to share? Inventive step. Next one. Inventive step. After two slides, you come across inventive steps. This is done. Next slide, please. This is done. Next slide. Uh, Next slide, please. Yeah, this is done. Inventive step. Next part. Next part. Novelty assessment. Yes. Sorry, the screen is not visible. Hello.
Ma'am, in my mobile phone it is visible, ma'am.
Yeah, this is the slide. Yes. Uh, Kindly keep the screens open, right? Patent types can be ranked at the level of inventive steps. First inventive step will be invention of patent. Invention patent, that is, it claims the it protects the novel technical solutions. Then will be the utility model patent that protects the product's shape or structure. Then the design patent that visual appearance of the, next slide please. Patents industrial applicability is also important. So, for example, if I consider, next slide, please. Kindly change this slide, please. Next. Hello. Next slide, please. Hello. Hello.
Okay, ma'am.
Yes, yes. If I talk about the industrial applications, the considering the semiconductors performance, we can see in this slide. Hello. You have changed the slide. Hello. This
Yes,
industrial
ma'am. Yes.
application part. The is previous one. Previous one. The previous one, sir. Hello.
Yes, ma'am.
Sir. Previous one. Yeah. Next. This is the separator slide. Next one. You have come seven. Next other. There is a slide, implications of industrial application, implications of semiconductor performance. This is an example in which we talk about different materials used: nanotechnology materials, smart materials, alternative. Hello, your screen is not visible, sir. Hello.
I'm checking, ma'am. Please wait. Ma'am, in my side, it is okay, ma'am. Maybe network issue from your side. Participants, please check your PPT in chart sheet and the comment section in YouTube. Thank you.
Hello?
Yes, ma'am. Yes, ma'am. You're audible.
Hello?
Yes, ma'am. You're.
Uh, yeah, prior art search. I was talking about prior art. Prior art is required before filing for any patent. For this, you have to go through the literature work, that is through books, certain trade and professional journals, certain advertising catalogs, certain government documents, registrations, and also already existing patents for which your prior art, this is the search for the similarity or similarity indexes is known as prior art search. So the types of prior art searches through novelty, non-patent literature search, biosequencing search, chemical or marker search if you are working on drug discovery, validity search, infringement search, landscape or state of art search, freedom to operate search, novelty search. These are the different types of priority search. The process of priority search is first define your invention, clearly outline the invention's feature, identify the keywords, list the relevant terms and classifications. Third, build search queries, construct effective queries using operators. Then, hello? Then, search the database that conduct search in material databases, multiple databases. Then, assess your findings, review and document search results. Hello? There is some music disturbance, please. Hello?
Ma'am, you're audible.
There's some music disturbance. Hello? Somebody is unmute. Hello? Hello? Hello?
Yes, ma'am.
There is some music disturbance.
Maybe,
Hello?
ma'am, maybe technical issue. Ma'am, we can stop the webinar, ma'am.
Is your
Maybe.
voice clear now? Hello?
Yes, ma'am, your voice is very clear. We can hear you.
Is the voice clear now?
Yes, ma'am, it's very clear.
Okay, now is my voice clear? Should I continue?
Yes, ma'am. Yes, ma'am. You should continue, ma'am.
Yeah. Okay. Thanks. Sorry and pardon for the technical glitches that we have faced with the talk. Okay. Done by patent databases. Google Patents,
Yes, ma'am. Continue.
Patent Scope, eNet, the Lens org. The three major free patent databases are USPTO, Patent Center, Google Patents, EPO, eSpaceNet. They are based throughout the world and you can access through internet. The majority of them being accounted or published in EPO. The largest patent free database which you can go through for your prior art search. There are also some commercial databases. The major providers of commercial patent database are LexisNexis, Mindsoft. These are the companies, and their LexisNexis has a total patent database. Mindsoft has Backbase. Procast has Dialog. Questel has QPAT, Orbit.com. STN has STN International and CAS. Thomas Reuters has DWPI and Thomas Innovations. These are the commercial patent database. So what is a patent? After going to the patent database, what is the patent search flow chart? We should know this. So the patent search flow chart should be like, if you have identified the databases with similar in title or abstract through WIPO, that is WIPO, say it is totally you have taken 402. In WIPO it is 231 and in EPO it is 171. So you deduct the excluded duplicates. Somewhere around 223 are the duplicates, say. So out of those 402, 223 duplicates you removed. So what you are left with? You are left with 179. Then include only patents with abstract and the full documents. Even here you can filter. Out of that 179, say 18 are not fulfilling your desired conditions. So 179 minus 18, 161 will be the remaining ones. Then out of that 161, the title and abstract reading excluded, and they are out of certain materials are out of your focus review. Then that could be around 121. So out of 161, if you remove 121, you are left with only 40 patents. The full patent for further reading you are left with is 40, but the certain around of 9 patents, say, are out of your focus review. Then you remove that also from 40 patents, the last 40 patents, you are left only with 31 patents. Okay, the final selection will be from the 31 patents. So what you did, you have gone through 4 different steps. First is identification, second is screening, third is eligibility of your patent, and third is inclusiveness or inclusion of your patents with the similar patents which are under study or review. Then you have to file for the invention disclosure. This is done online in the online portal. You have to click the disclosure form link and start disclosure process there. Then when you submit, the status appears to be in progress. It comes mentioned like that. Fill out the disclosure form, click the submit button. Then after submission, the status will show you under review. There will be a window, it will show you under review. After that the patent office staff reviews the submission. If the disclosure report is complete, then the status appears to be accepted and the disclosure is assigned for licensing officer for review. Okay, this goes in the disclosure, invention disclosure. If your after the under review part, if the staff review submission during that, if they do not find your disclosure as complete, they again return the disclosure to you, to the inventor, and your status will appear as returned here. Initially it was under review. Now it will appear as returned. Next stage will be, again you have to make the changes required through the review. Then again click to submit after making the changes. The process will again proceed. Then you will get a provisional patent. What is a provisional patent? Provisional patent gives 5 steps. After 5 steps of processes, you will come to the level of provisional patent. First, define your idea and ensure it is novel and unique. Second, conduct a patent search to ensure that you are first to file. Collaborate with the patent expert on your application. Look, you are good at invention, you are good at technological knowledge, you are good at research work, everything is good. But the technical aspects of filing the patent, drafting it, requires some technical, what is it? The legal-technical, I think I can say it is legal as well as technical expertise. So you need to have a patent expert that can be an attorney or a patent attorney. So you can take the help of them and prepare your text and drawings along with them as per their guidance, and proceed for the filling and submit your patent idea, patent documents, forms, Form 1 and Form 2 for submission, so that it can be shared for the procedure of provisional patenting. Now, structure of patent specification. What is structure of patent specification is how you design the title, the abstract, the summary, the drawings, the claims, etc. comes under this classes. These are also called as components of patent specification. Title should be very, very clear. The specific features of invention should be clearly identifiable, mentioned in the title. And this should be within the limits of 15 words. Second, prior art and problem to be solved. The applicant should give a proper statement to the effect of the closest prior art known by the applicant. That is, yes, I have seen this invention. There are certain inventions, but my invention does not, is totally different. It has this novel feature. Object and summary. Specifications should also state what objectives you are going to utilize, or what objective is your invention helpful in, and what problem it is aims to solve. That also has to be made into a summary. Description and drawings. When you describe, your description should be very clear, concise, and very precise. About the description, what are the salient features of an innovation, salient features of an invention, along with the nearest possible clear diagram that you can draw. Here also you can take up the help of certain tools. Certain AI tools are there, which are available right now. That will be another aspect. We'll have a talk on that in the next session. Then claims in abstract. Yes, this is the important part of your patent. The applicant should clearly mention the claims. What do you claim with your patent, patentable product or prototype? These are the things which are highly claimed, because this is not visible or witnessed in any other nearby or similar product or prototypes. That can be done. And abstract should be in a clear, distinguished, easy, understandable language. Components of a complete patent specification involve. Again, I'm showing you the slide with at a glance table. The section is title. Its title's purpose is clear, concise name of the invention. Then abstract. Abstract gives you a brief. It should be a brief technical summary, around maximum it should be 150 words. Field of invention. In which area of technology is your invention falling in? Background. How much prior art and problems are addressed? Summary of invention. Important key features and technical solutions your patentable product is providing, that has to be described. Detailed description, in-depth working of the invention. It should not be a simple description. It should be clearly mentioning what is going to move, what is going to be stable, what mechanism is happening, everything has to be clearly mentioned. Then claims, the legal scope of protection. Okay, it is most critical because your claims will highlight your novel features. Then drawings, yes, drawings gives a pictorial representation of your prototype to the examiners. That at least, and it has to be represented in all the angles from upper view, lateral side, base view, etc. etc. Then examples or embodiments, uses of cases or working models. Background and prior art, anyhow, I have detailedly discussed this, but prior art search basically falls under 4 categories: patent validity search, patentable search, freedom to operate, and state of the art search. Validity search invalidates the claims of asserted or blocking patents, and also helps in the evaluation of strength and enforceability of patent. Patentability search assesses the novelty and non-obviousness of the invention. Freedom to operate, it determines if your product or service infringes on existing patents in a given jurisdiction. State of the art search, it gives an insight in the existing technologies and patented innovation within the technology area. Then, how will you draw patents? Your patent prototype drawings. A patent application or patent drawing may contain patent drawings of invention, some of its embodiments, especially the implementation or the process or method of carrying out the invention, or the prior arts. Okay, the drawings may be required to follow certain law or legal implications under certain jurisdiction. If it is falling under certain categories, it is a wide scope. So this point has to be. This is an example I've given for patentable drawing. A patent drawing, the bicycle ones, the old ones. It is somewhere around. The patent has been done in April 8th, 1890. Okay. This is for the cycle pedal design. Okay, cycle pedal invention and the belt pulley, etc. Okay, and this is an very old example. Then, how do you claim? And what are your claim drafting basics? You should work. You should have an homework on it. Prepare the claim list first. Write down or draft your claims with specifications and drawings. Discuss the draft claims with the inventor early in the application draft process. Review, revise the claim against the specification that has been completed. That means you have to go on working on with already existing design or already existing inventions along with your own specification and what novelty and what unknown, what not obvious substances or features are there in your prototype that has to be mentioned in the claims clearly. Excuse me. So your claim should be both broad and narrow. It should be including varying scopes. The claim set of varying scope should not be just an independent claim but also have a narrow dependent claim. One claim set for each of products or method of making and method of using should be considered. So independent and dependent claims are coexisting here. So what are they? Independent claims are standalone. They contain all the claims and they do not have any limitations. Always they are broader than the dependent claims. One independent claim may be broader than the another independent claim. Whereas Dependent claim is a reference to a specific independent claim, includes all limitations of the recited independent claim. It adds more limitations to the independent claim and also follows the immediate independent claim. So, claim drafting examples. Examples of patent claims here I am giving you. The claim for an automobile. A self-propelled vehicle comprising of these points. That is, a body carriage having rotatable wheels mounted thereunder for enabling said body carriage to roll along the surface. Okay. An engine mounted in said carriage for producing rotational energy. Okay. Means for controllably coupling rotational energy from said engine to at least one of the said wheels, whereby said carriage can be self-propelled along said surface. Look at this. How complicated it is. If we are inventing, I know I am inventing only my vehicle or an automobile. But the technical language here asks you to mention each and every aspect of it. Another example. Claim for process of sewing. Okay, stitching, sewing. A method for joining two pieces of cloth together at their edges that comprises the following steps. Providing said two pieces of cloth and positioning them together so that an edge portion of one piece overlaps on the adjacent of the other, and passing a thread repeatedly through along the length of the overlapping portions is sequentially opposite directions and through sequentially spaced holes in said overlapping adjacent portion, whereby said piece of cloth will be attached along the said edge portion. The sentences I read out appears to be very complicated, whereas you know what a sewing process. Here, while you are claiming certain thing, you should claim in each and every component of it, every process that is occurring, matter that is going to cause as a resultant. So, the claims should be highly specific. Anyhow, there is also a claim in my slide for pencil also. So, these are the methods how you claim. Common drafting errors that are created by or generated by beginners. Beginners, rather even the pros or the professionals also at times end up with doing some errors. First is the inadequate prior art search. It is like, yes, my invention is unique, my work is unique, nobody in the world has done similar work. No, you are under the wrong impression. You have to go through prior art search. Poorly defined invention. Yes, my invention is there. It is an automobile. What type of automobile it is? Is it a petrol run, diesel run, electricity run? Whatever it is, you have to mention clearly. Overly broad claims. Even if it is, you have claimed everything, but repetition and unnecessary matter involvement concerned with the claims, describing it in a very, very, very deeper way, it's like an essay type, doesn't provide any clear identification. Insufficient details in the description, even that is also problematic. No, you should be very specific, okay, with this. Failing to disclose the best mode. Yes, you, in what best way you can utilize it for the purpose. That has to be clearly mentioned. Ignoring patentability requirements. First of all, you self-proclaim that it is novel. No, you have not done any search. You have not gone through any patent scope or any patent databases. You cannot claim it like that. Okay? So, ignoring patentability requirements. Inconsistent terminology. Okay, here for example, if I say I am using acetic acid 10 ml for this reaction. After that in another paragraph I mentioned purified vinegar is used. 10 ml again for the reaction to occur. So am I using the same term? Though the material is same, I am talking about vinegar. That is yes, that is a trivial name, whereas the chemical name is acetic acid. But am I giving the correct terminology? It is totally technically disorder, or rather, technically it is not suitable. So it should be a proper terminology which is followed throughout the world. That has to be identified and that has to be included. Overlooking the role of drawings. Okay, I am unable to draw. I don't know, but my prototype is ready. But your attorney or the patent office does not identify your prototype in physical terms. You have to submit it in digital form and as well as in the documented form. So for this, diagram is required. Without diagrams, it is very, very impossible for the patent to be filed. Neglecting to include multiple embodiments. Yes. I have mentioned the novel feature of my invention, but I am not talking about any other parts or components present in it. That is totally absurd. Because you are designing something and inventing some different thing or novel thing that has to be included. Every aspect has to be included. Submitting an incomplete application. Yes. Not mentioning the description, not writing the abstract, directly mentioning the claims also gives a problem. Mismanaging filing deadlines. Yes. Once you have filed, your process starts. So you have to maintain the timeline. Ignoring patentability requirement. Again, this point is repeated, sorry. That is, even if it is not novel, even if it is not obvious, you are claiming it to be a patentable one. Inadequate claim strategy. You don't claim properly. No clear claiming aspects. Excuse me. Overlooking international consideration. Yes. I'm in India. I'm working for Indian citizens. My invention is for India. So, what if the same material or same invention is there in Europe? Are you not going to consider? That is not patentable because it's not unique. Throughout the world, it should be unique. Okay? Not considering commercial aspects. Yes. My invention is there. I'm using it because it is clearing or causing me the ease of convenience. But does it have any commercial aspect? Does it generate some revenue? No. Then it is only for your personal use. That cannot be claimed as a patentable material. Okay. Neglecting post-grant maintenance. Yes. After provisional certificate of your patent, there are certain rules and regulations that you have to follow. That if you neglect, then it is going to be dissolved. Inadequate documentation, not providing any proofs, not providing any prototypes, not appearing, not giving the proper review and for failing to review and refine your claims. That is also another problem. Indian patent filing process involves filing on a particular date. Formal examination is done. If the incomplete requirements are there, the applicant will be notified in 3 months. If the applicant does not fulfill, then it is withdrawn. If the applicant fulfills, then it undergoes for publication for 6 months. Soon after that, 18 months from the filing date or date of priority, if you apply for date of priority, there is a request for, request asked whether you want for a substantive examination. Yes, if you say, then maximum 36 months for filing date. Then, if it is requested, then the substantive examination is done. From the date of that, 36 after 36 months, it is granted. If the examination fails, then it is rejected and asked for you to appeal. If during the appeal, if your claims and the invention is identified to be accepted, then it is going to be under success and the granted your patent will be granted. If it fails to claim, then it is rejected. Once you are under the granted category, the issuance of grant certificate is done. This is the IPR process of India. First, examination report response strategy. This is very important because it falls under section 14 of patent 1970. Because formal examination at IPO is that is Indian Patent Office is done, and it is the responsibility of the applicant to respond within the statutory deadline. So this is a tabular form I had given in the slide. First, FER is done in ordinary examination is done in 12 to 24 months. Expedited means fast pace. Okay, that is done in 1 to 3 months. Initial FER response 6 months, and expedited also 6 months. Maximum response window is open till 9 months. Even that is 9 months for expedited. Form 4 anywhere between 6 to 9 months, whereas expedited also same timeline. Form 3 months from FER date, whereas expedited is also same. Second examination report SER issued after FER originally within 9 months, whereas expedited also same. Hearing notice period minimum 10 days under Rule 120, even that is for expedited. Written submission within 15 days of hearing date, that is also for expedited. Then okay, there is every possibility that I am working with you. We both have worked together for the patenting, but I have some opposition. Okay, it can be 2 categories. I claim the opposition either before patenting or after patenting. So this is pre-grant and post-grant conditions. These fall under the Patent Act of 1970. Pre-grant under section 25(1) and post-grant under section 25(2). Who can file? Any person can file the pre-grant opposition, whereas post-grant only the interested person. Time to file? Pre-grant opposition is only after publication before grant, whereas post-grant within 12 months of grant. Legal form 7A, whereas post-grant Form 7. Decision authority will be the controller of IPO, whereas post-grant opposition board plus controller. Impact may prevent the grant if it is pre-grant opposition. Post-grant opposition it may revoke or amend the filing. Trademark filing, it is the trademark registration processes. Trademark search is done. Then e-filing of trademark application is done. Next, third stage, issuance of exam report, if any. Then advertisement of TM journal that is given to the company, and till the final registration is done, the TM can be written on the brand name, logo, anywhere. That means it is under trademark. Once it is done, the trademark registration is done, then you can write the R in circle, that is registered brand name. Copyright registration, this benefits of having a copyright is it gives legal protection and evidence of ownership. It gives legally enforceable exclusive right to individuals. It enhances protection of infringement, increases brand value and economic value. It gives international recognition. For example, you have created a piece of music, then it is exclusively yours. That tune is yours, that music is yours, and hence you are worldwide recognized because of that exclusive signature style. Then industrial design registration. This follows certain industrial application is first filed. It is generally from patent offices of Mumbai and Chennai. Then examination of design is done, whether the application and documents, that is a formal requirement. Whether design applied to an article is registrable, that is also identified. Then the examination report is generated. Then the examiner will communicate to the nature of objection to the control of design. for issuance of statement of objection. This whole part till response filling against examination report. This whole part takes 6 months duration. So after that, if the response is not accepted, again it will go for examination report. If the response is accepted, then the registration of design is done. If the application complies with all the requirements laid down under the Act and rules, communicated in form of statement of objections, the application shall be registered for. Then the registration and grant certification is given through the controller of design. This again takes, after response acceptance, 6 months period of time. IPR for startups. This is an important thing because startups have innovation. Innovation is to be safeguarded. So, patent protection, safeguarding innovation, trademark protection, building brand identity, copyright protection, securing creative works, trade secret protection, confidential business information protection, design rights and emerging IP areas, IPR and startup funding are the strategic advantages for startups to have IPR. It also helps in technology transfer. Typical steps include knowledge creation, disclosure, assessment and evaluation of excuse me, intellectual property analytics, intellectual property valuation. It helps in intellectual property protection, fundraising and technology development, helps in marketing, commercialization, product development, and also has market impact. So, if IPR for the startup is done, then licensing and commercialization will be an easier part. You innovate. During the innovation, you do the research, disclose, evaluate, patent, and send to market. Spin out your product and look out for the commercializability. Then go for licensing, develop the product to advanced levels and deploy. Then the benefits will be implicated, and the benefits may lead to new research aspects and newer. This is an infinity ring. Innovation and commercialization are both go hand in hand, and it is an infinity ring. Certain landmark Indian cases in which patent fight have been done was by Bajaj Electricals Limited versus Gaurav Bajaj and company. The Gaurav Bajaj has claimed certain term like under the supervision of Bajaj or something like that. So Bajaj Electricals have claimed that it is an infringement of their patent. Marico Limited and Abhijit Bansali. It is a famous case of parachute oil being called as an hair oil, but it is an edible oil. That Marico has converted it into a safe edible coconut oil. Okay, that is another part. Then Samir Wadekar and Netflix, he has used some movie clips or some video clips for his own. He was an influencer for his own YouTube channel. Star India Private Limited also has the same case. ISKCON versus ISKCON Apparel Private Limited. Here it is concerned with devotion and is Krishna conscious, whereas apparel is claiming that it gives a confusing statement that is concerned with ISKCON society. Now we have some resources from WIPO. I am going to share this. WIPO Academy for IP Education Hub. That is, you can get some courses there. WIPO Green Network. It gives you some information on the eco-friendly aspects. IP information is also there. Lex database gives you all the database concerned with worldwide patents, and IP portal is where you can file and deal with the form, documentation, etc. WIPO Translate also helps you in understanding different languages. Say some patent is published in Russian, then you can read, translate it, and get it in your own language or English or something like that. Okay, then there are different categories of the WIPO: genetic resources, traditional knowledge, and traditional cultural expression center, etc. WIPO also has a publication and platform wherein you can publish your patents or the IPR designs, etc. WIPO also has alternative dispute resolution mechanism, the arbitration and mediation center, where you can claim if your patent has been infringed somewhere, or if your copyright has been infringed somewhere, then you can claim and let that dispute get resolved at the center. So WIPO has these restrictions. Now, always you should have a best practice checklist before patenting. That is, 5 best IPR best practices that a business. Why I am saying business specifically? Because anything you invent, anything process or design or whatever, that you want it to be commercialized ultimately. Okay, so it should go through these 5 best IPR strategies or practices. Gain adequate knowledge about your IP. Adopt proper legal strategy for IP protection. Educate the IP team via training and courses. Limit IP access and use data encryption. IPR due diligence and proper governance is required. These all 5 steps if you follow, then the best possible patentable strategy is developed. Thank you all for your patience listening. Queries are welcome. Thank you all participants. And in spite of certain technical glitches, you people have been very patientful. Thanks a lot. Any queries? May I have some? Hello? Are there any queries?
No, ma'am.
No, ma'am, no.
Okay, ma'am. Thank you, ma'am. Thank you for explaining about some topics
Thank
like
you so much.
pay,
I hope I
patent.
was very clear. Yeah, I hope I was very clear because I could do as much as possible in spite of the technical glitch. So many people have given their precious time. I'm thankful to the participants throughout the country for being with me and for the patientful listening. Thank you all.
Thank you, ma'am. Thank you so
Thank
much
you,
for
ma'am.
this wonderful session.
Thank you, ma'am.
Thank you. Thank you.
Thank you. Thank you,
Hope you
ma'am.
got some glimpses of patentable idea and how to patent, what are the documentation processes. In case if you have any doubt, you can very well contact me on Dr. Preeti Chincholikar at gmail.com. Thanks a lot. Yeah. May I leave? Hello?
Okay, ma'am. Okay, ma'am. Okay.
May I leave the session, please?
Okay, ma'am.
Thank you.
Yes, ma'am. You can
Thank
leave
you
this
all.
session.
Thank you.
Thank you.
Thank you, ma'am. Patent, copyright, trademark, design, filing basis, strategy for protect research and innovation. Before we concluded, we would like to thank our sponsor JVK Technologies. JVK Technologies offers a publication services including scopus, essay, patents, copyright, thesis, and textbooks, etc. For any publication assistant, you are warmly invited to join their WhatsApp group. Link is in the chat box as well as comment section. We also thanks all the participants for joining us today. Please fill the feedback form for the certificates. Those who fill the feedback only will get the certificates. To receive the certificates, you must fill out the feedback form and join the WhatsApp group. Those who fill the feedback form can leave the meeting. We also thanks all the participants for joining us today. Please fill the feedback form for the certificates. Those who fill the feedback only will get the certificates. To receive the certificates, You must fill out the feedback form and join the WhatsApp group. Those who fill the feedback form can leave the meeting.